criminal law. So for today, under criminal law, we are going to be studying the history of Nigeria criminal law, and we'll be discussing how the criminal code was gotten from, how the penal code was gotten from. Why is it that in the north they are operating the penal code? Why is it that in the south they are operating the criminal code? So for this particular video, we are here to answer that particular question. So we begin. Before the advent of colonial rule in Nigeria, there was various customary criminal law. So before the British came to Nigeria, there was various customary criminal law. It's not that before the British came into Nigeria, there was nothing like crime. Before the British came, there were acts that constitute crime. Before the British came. Now, in the north, there was the Maliki school of thought. That was their customary criminal law. In the south, their customary criminal law was clearly written down because they didn't know how to write it. So that was the difference between the customary criminal law in the north and in the south. In the north, it was based on the Maliki school of thought, while in the south, it was clearly unwritten. So there was customary criminal law before the colonial masters came into Nigeria. Now, in 1863, the colonial masters introduced the common law crime to the colony of Lagos. Now, the colonial masters have come to Nigeria already. They have come to the colony of Lagos, and in 1863, they introduced the common law crime to the colony of Lagos. The question you will now ask yourself, what of the customary criminal law of Lagos? Did it stop working after the colonial masters introduced the common law crime to the colony of Lagos? No. The customary criminal law was still in operation. Why the common law crime was in operation in the colony of Lagos, the customary criminal law was still in operation in the colony of Lagos. Now, we'll move forward. It was not suitable because it wasn't easily ascertainable. There was need for clearly worded criminal principle. Now, this common law crime that was introduced to the colony of Lagos was not suitable. It was based on judicial precedent. It was not ascertainable. You could not even predict it. So that it was not suitable for the colony of Lagos. Now, in 1904, Lord Lugard introduced the criminal code to the northern part of Nigeria. Now, that's that for the colony of Lagos. We are now in the northern part of Nigeria, where the customary criminal law based on the Maliki school of thought was in operation. And now, in 1904, Lord Lugard introduced the criminal code to the northern part of Nigeria. In 1904, Lord Lugard introduced the criminal code to the northern parts of Nigeria. Now, this did not still stop the customary criminal law of the northern part to stop working. The criminal code was in operation. The customary criminal law based on the Maliki school of thought was still in operation in the northern parts of Nigeria. So you move forward. In 1914, Nigeria was amalgamated, and in 1916, the criminal code was extended throughout Nigeria. So in 1914, both the southern part of Nigeria and the northern part of Nigeria were brought together in 1914. And in 1916, the criminal code, which was first introduced to the northern part of Nigeria, was now made applicable throughout the whole Nigeria. Both to the south, the criminal code was applicable, and both to the north, the criminal code was still applicable due to the fact Nigeria had been unified. So that happened in 1916. And the customary criminal law of the south was still in operation. The customary criminal law of the north was still in operation, while the criminal code was not applicable throughout the whole Nigeria. Criminal code was gotten from the Queensland in Australia, and it was drafted by a man named James Fitzstone in 1878. So this criminal code that was first applicable in the northern part of Nigeria before made applicable in the whole Nigeria after amalgamation in the year 1916 was gotten from the Queensland in Australia, was gotten from the Queensland in Australia, and was drafted by a man named James Fitzstone in 1878. Now, you now ask yourself, Nigeria have been unified. The criminal code is now applicable not only to the northern Nigeria, but to the whole Nigeria. What then happens to the customary criminal law? What happens to the customary criminal law of the south and of the north? Is this still functioning? The answer is yes. It was still in operation. There was questions like this, but however, by section 4 of the criminal code, it was preserved. So section 4 of the criminal code, the customary criminal law was preserved. So let's look at section 4 of the criminal code. Now, section 4 of the criminal code provides that's the criminal code of before, not now. No person shall be liable to be tried or punished in any court in Nigeria other than a native tribunal for an offense except under the express provisions of this code or some order in council made by His Majesty for Nigeria, or under the express provision of some statutes of imperial parliament which is in force in Nigeria, or from parts of the law in Nigeria. So by the word order than a native tribunal, it shows that the customary criminal law was still in force in Nigeria. So despite the fact the criminal code was made applicable in the whole of Nigeria, the customary criminal law of both the south and the north were still in operation. Now, you move forward. However, there were issues as to the punishment. So, several issues arose. Now, the customary criminal code is not applicable to the whole Nigeria. The customary criminal code is still in operation, and the criminal code which was brought by the British is still in operation. So there were issues as to the punishment, because why the customary criminal code we say 4 years imprisonment, or the African criminal code we say you are hereby sentenced to imprisonment. The criminal code can be said that you are sentenced to death. So there were controversies as to the punishment. So the punishment of the offense in the criminal code will be different from the punishment of a particular offense, the same offense, according to customary criminal law. So there were issues. Now, there was an amendment to resolve this issue. There was an amendment in the year 1963. So by the amendment of 1963, it came to 1933. By the amendment of 1933, it came to resolve these particular issues, and the word other than native tribunal was deleted. So, by pursuant to that section 4 of the criminal code, there was a particular word other than native tribunal. So by this amendment, that word was deleted, and people were like, they have deleted this particular word. Does it mean that customary criminal law is no longer applicable and it's only the criminal code that the British brought that is applicable? The answer is no. That word, that sentence, other than native tribunal, was deleted to resolve the issue of punishment. And what was the answer that this particular amendment gave? Now, by this particular amendment, which came to resolve the issue and deleted that particular sentence, it clearly means that if a particular offense, if an act is an offense in the criminal code and is also an offense in the customary criminal law, it means that the punishment is going to be based on the criminal code. That was what this particular amendment of 1933 was about. So the British amended that section 4 of the criminal code. They amended the section 4 of the criminal code and deleted the word other than a native tribunal to show that when Mr. A commits the offense of murder, commit an act of killing someone, and this particular act was an offense against customary criminal law, and this particular act was also an offense under the criminal code, it therefore means that the punishment prescribed by the criminal code is what the court is to give. Yes, this Mr. A can be tried according to criminal law, according to customary criminal law. But however, since the act is also an offense under the criminal code and also an offense under the customary criminal law, then the punishment to be given is going to be based on the criminal code. Now, this amendment was done to resolve the issue of punishment. So, we move forward. Now, this was reflected in the case of Goomba versus Gudu Native Council, where the appellant was charged for homicide. So, in the case of Goomba versus Gudu Native Authority, in this particular case of Goomba versus Gudu Native Authority, the appellant was charged for homicide and he was sentenced to death despite the fact that there was evidence showing that it was manslaughter. And this appellant act constituted an offense in the criminal code, and it also constituted an offense according to customary criminal law. Instead of the lower court to prescribe the punishment given by the criminal code, the lower courts gave the punishment according to the customary criminal law instead of the criminal code, despite the fact that the appellant act constituted an offense against the customary criminal law and also against the criminal code. When the appellant appealed to the upper court, the court held that no, you cannot prescribe, where the court held that where an act is an offense under the customary criminal law and also an offense under the criminal code, the punishment prescribed by the criminal code is what is to be delivered. That was what the court held in this particular case of Goomba versus Gudu Native Authority. So it was also reflected in section 3 of the Native Court Ordinance. Now, let's also look at section 10 to better clarify this. Let's look at section 10, paragraph A of the Native Court Amendment Ordinance of 1951. Let's look at that particular section. Now, it says inter alia, even though the act or omission constituting the offense may also constitute an offense under the provisions of the criminal code or any other enactment, and the native court shall not impose a punishment in excess of the maximum punishment permitted by the criminal code or such other enactment. So when Mr. A commits an offense, and that offense is a crime under the customary criminal law and also a crime under the criminal code, what this particular section is trying to say that the punishment to be imposed on Mr. A must not be more than the one prescribed by the criminal code. So yes, the native courts, yes, Mr. A can be tried according to customary criminal law. But however, in prescribing a punishment, in giving the punishment, you have to give it according to the criminal code, because that act was also an offense under the criminal code. So we will move forward. This was also reflected in the case. So similar position, similar affirmation was given in the case of Mazabo versus Sokoto Native Authority. In this Mazabo versus Sokoto Native Authority, to better clarify it, the appellant was sentenced to death. The appellant was sentenced to death by the native court, despite the fact there was a defense of provocation. Despite the fact there was a defense of provocation, the appellant was sentenced to death by the native court. However, where the appellant appealed to the Federal Supreme Court, because it was the Federal Supreme Court back then, the Federal Supreme Court held that you cannot give a punishment in excess of the penalty prescribed by the criminal code. So where an act constitutes an offense under the customary criminal code and also constitutes that offense under the criminal code, the penalty to be prescribed should be the one prescribed, it should be the one given by the criminal code. Now, we'll move forward. In preparation, now the question you now ask yourself, this is it now. How did the penal code come about? Why is it that the Southerners are not using the criminal code, while the Northerners are not using the penal code? Now, here comes the twist. In preparation for independence, there was reformist group in northern Nigeria, and they challenged the application of the code. So in preparation for independence, reformist groups emerged from northern Nigeria, and they said that we cannot accept this criminal code again. We cannot accept the application of this criminal code over us again. They said no, this criminal code cannot be applied over us again. No way, it cannot be applicable over us again. Why did they say so? They said because it didn't contain certain traditional Muslim offenses. They were like, this criminal code that the colonial masters are saying should be applicable to the North did not even contain certain offense, so it should not be applicable to us. Now, for this particular purpose, a panel was created. They brought a panel, and this particular panel was created to resolve this particular issue. This panel was created to look at the criminal code and try to resolve this particular issue. Now, after looking at it, the panel recommended the penal code. This particular panel, after looking at the situation, after looking at the circumstances, after taking a microscopic view at the criminal code, they brought their result, and they said that the penal code should be brought to northern Nigeria. And that was how the penal code was brought to northern Nigeria after the decision of the panel. And this particular penal code was brought from Sudan. The penal code of Sudan was introduced upon recommendation by the panel. The penal code of Sudan was brought to the northern Nigeria. And this Sudan code that we are talking about was based on the Indian code that was prepared by Lord Macaulay. So after recommendation of the panel, the penal code of Sudan, which was in pari material with that of India, was brought to Nigeria. So it was brought to Nigeria. The recommendation was accepted. The penal code was brought to northern Nigeria, not southern Nigeria, to northern Nigeria. And it was enacted, and it came into effect on 1st of October 1960. So on 1st of October 1960, the penal code came into effect. So the northern part of Nigeria started using the penal code, while the southern part of Nigeria was still using the criminal code, while the customary law of the southern part of Nigeria was still in operation. The criminal code was still in operation in the southern part of Nigeria. However, for northern Nigeria, after the recommendation of the panel, the law applicable was now the penal code. Finish. Then we move forward. Now, the penal code that was brought to northern Nigeria criminalized certain offences. That was why the groups emerged. They were like, certain acts are not an offence under the criminal code, so the criminal code should not be applicable. So the penal code that was then brought to northern Nigeria filled the loopholes of the criminal code. It filled the loophole of the criminal code. That is why adultery, which is a crime in northern Nigeria, pursuant to section 387 and section 388 of the penal code, is not an offence under the criminal code. In the southern part of Nigeria. So this penal code filled the loopholes. So adultery was made an offence under section 387 and section 388 of the penal code. Drinking of alcohol was made an offence under section 403 of the penal code. Insulting the modesty of Muslim women was made an offence under section 400 of the penal code. So you see, the penal code filled the loopholes. What was not an offence in the criminal code was made an offence in the penal code. So it fits the loophole. It resolved the issues of the groups that emerged for northern Nigeria. Now, that is it for northern Nigeria. What about the southern Nigeria, where there was operation of the customary criminal law and there was also operation of the criminal code? How did the southern Nigeria later resolve theirs? Now, let's look at it. So, by section 3, sub 2 of the penal code, the customary criminal law was no longer applicable in the northern part of Nigeria. So the customary criminal law was no longer applicable in the northern part of Nigeria. The criminal code was no longer applicable in the northern part of Nigeria. And what was then applicable was the penal code. So now, let's now look at the southern Nigeria. How the southern Nigeria resolved their issue. Now, in the year 1958, a constitutional conference was created and it was decided that the customary criminal law should be abolished. Now, this is it for the northern Nigeria. So in the year 1958, a constitutional conference was created, and this constitutional conference decided that let this customary criminal law in the southern Nigeria be abolished. Let only the criminal code be in operation, and let the customary criminal law of the southern Nigeria be abolished, so that just like the north that is operating the penal code, the south will only be operating the criminal code, and there will be nothing like customary criminal law in the south any longer. So that was how the customary criminal law in the southern Nigeria was abolished. Thus, by the provision of section 21, subsection 1 of the 1960 Constitution, section 22, subsection 1 of the 1963 Constitution, Republican Constitution, section 33, subsection 12 of the 1979 Constitution, and section 36, subsection 12 of the 1999 Constitution, customary criminal law was abolished. And the only law that was now in operation criminalizing act in the south was only the criminal code. That is how the north are operating the penal code, and the south are operating the criminal code. So, by virtue of section 21, subsection 1 of the 1960 Constitution, customary criminal law was abolished. Same thing could be seen in section 22, subsection 1 of the 1963 Republican Constitution. Same thing can be seen in section 33 subsection 12 of the 1979 Constitution. Same thing could also be seen in this present Constitution that we are using, which is the 1999 Constitution, by section 36 subsection 12 of the 1999 Constitution. Customary criminal law in the South was abolished. Now you ask me, what is over there in section 36 subsection 12 of the 1999 Constitution? Now, section 36 subsection 12 of the 1999 Constitution provides that a person shall not be convicted of a criminal offense unless that offense is defined and the penalty is therefore prescribed in a written law. So a person shall not, nobody should be convicted of a particular crime. Nobody should be convicted of a particular offense unless that offense is defined and penalty prescribed in a written law. That was what was provided in section 36 subsection 12 of the Criminal Code. And you know that customary criminal law is unwritten. The penalty is not prescribed. The act is not defined. It's not customary criminal law. It's not written down in any written law. So by this particular provision, which was given by the groundnut, which is the Constitution, customary criminal law was abolished in Nigeria. That is why rape is defined in section 358. The punishment is prescribed in section 359. That is why it is stated that a person shall not be convicted of a criminal offense unless that offense is defined. Rape defined, section 357, and the penalty is prescribed. Rape punishable under section 358 of the Criminal Code. So for somebody to be penalized for a particular offense in the South, that offense must be written down. And this is how the customary criminal law in the Southern Nigeria was abolished. That is how we came about the Penal Code, which is applicable in the North, and we also have the Criminal Code, which is applicable in the South. Now, this was given judicial blessing in the locus classicus case of Eoko versus Fagbemi. Eoko versus Fagbemi, where the appellant was convicted. In Eoko versus Fagbemi, the appellant was convicted for adultery at the lower court. However, when upon appeal by the appellants to the High Court, the High Court held that adultery was not an offense, was not written down as an offense in any written law, and for that reason, the appellants cannot be held guilty of a particular offense that was not written down. However, if this adultery was committed in the North, it should have been an offense. But by virtue of the Criminal Code and by virtue of section 36 subsection 12, which abolished the customary criminal law, adultery was no more an offense. So the section 36 subsection 12 was given judicial affirmation in the case of Eoko versus Fagbemi, which is before any person can be convicted of a particular offense, that offense must be written down and the penalty must be prescribed. So this is how we came about the Criminal Code, which is applicable in the North, the Criminal Code which is applicable in the South, and the Penal Code which is applicable in the North. So this is the history of the Nigeria criminal law. By name, I am Japhet Okaka Ebosetali. Thank you so much for watching.
Down, I have to pick myself back up, and when I fall down, I have to pick myself up. Stand up.